You move out, you sign a new lease. 5 years go by, and you figure that since you've been living completely separate lives, you're basically divorced, right? The reality of Canadian family law is much less forgiving. Without a formal order signed by a Supreme Court judge, decades of physical distance have absolutely zero legal impact on your marital status. You are still married. So how do you actually end it? If you both agree on everything and just sign a piece of paper, can you get one of those 30-day quickie divorces you hear about? No. The Canadian legal system does not offer a VIP fast track, regardless of how amicable your split might be. Instead, the speed of your divorce is strictly governed by 3 non-negotiable statutory rules. Think of them as 3 separate clocks ticking in the background of your separation. Understanding exactly how and when these 3 clocks run dictates whether you can move on with your life in a matter of months, or if you will be trapped in legal and financial limbo for years. The first countdown begins on the exact day you decide the marriage is over and you communicate that decision. This triggers Section 8, subsection 2A of the Federal Divorce Act. It mandates a strict 1-year separation period. A judge is legally barred from granting your divorce until you have lived separate and apart for exactly 365 days. But this doesn't mean maintaining 2 households. You can live under the same roof, provided you act like roommates, maintaining separate bedrooms, chores, and finances. Couples can attempt reconciliation and resume their relationship for up to 90 days. This 90-day period essentially pauses your separation countdown. If reconciliation fails, you pick up right where you left off, without starting a brand new 365-day clock. This inflexible first clock is the state's way of ensuring the marriage is irretrievably broken before they intervene. That makes this 1-year wait an absolute baseline for everyone. When day 366 arrives, the mandatory wait is over. Now you enter the processing phase, and the timeline here is dictated entirely by how well you and your ex can cooperate. This is where you hit a massive fork in the road, one that affects both your calendar and your wallet. If you agree on dividing property, support payments, and parenting responsibilities, you take the uncontested path. You can apply for a desk order divorce, where a judge reviews your paperwork, without you ever stepping into a courtroom. This efficient path typically takes only a few weeks or months to process. The other option is the contested path, triggered when spouses fight and demand a full trial to settle their disputes. Demanding a trial requires exchanging evidence, attending case conferences, and waiting for court dates, which regularly extends your divorce timeline by an entire year, or much longer. It also inflicts severe financial damage. A standard family law trial can easily consume upwards of $15,000 in legal fees. While the federal government rigidly controls the first clock, you and your spouse completely control the speed, cost, and pain of this second clock. Let's assume you chose the fast route. You cooperated, filed the paperwork, and the judge finally signed your uncontested desk order. You might think you're free to remarry tomorrow. You aren't. There is one final hurdle. Section 12, subsection 1 of the Divorce Act. The judge's signature does not grant an immediate divorce. Instead, it triggers a mandatory 31-day window where your legal status is essentially placed on ice. This is a strict federal rule designed to leave room for any last-minute legal appeals to the judgment. It is only on the dawn of day 31 that you are officially severed from your ex-spouse and legally free to remarry. That marks the absolute, statutory end of your divorce timeline. When you look at the complete timeline, a harsh reality becomes clear. You cannot negotiate with the federal government on Rule 1, the 365 days of separation, or Rule 3, the 31-day appeal window. Those 2 boundaries are set in stone for every Canadian. The only dial you can turn to speed up your divorce is Rule 2, your processing style. Cooperating with your ex and choosing an uncontested joint application is the ultimate legal shortcut. It bypasses the courtroom entirely and slashes years off your wait. Keep in mind, exact processing times still depend heavily on the backlog in your specific province, your exact separation date, and the complexity of dividing your assets. To get total clarity on your exact timeline, and to ensure your desk order is filed flawlessly the first time, you need expert guidance. Book a legal consultation with Pax Law Corporation today and take control of your timeline.